Just to remind you, Judge, this is when she pled out, and you gave her some time to get her affairs in order.
Right.
And just told her to show up today. And
Okay. And
She
I
pled-
somewhat recall that, but
She pled to 3, yeah.
thank
So
you.
there's no report here,
Okay,
Yeah.
because we really didn't agree.
right. No, I understand all of that, but I don't have anything to tell me
just
what
need
I
something
did.
from you.
I just can't.
I can probably say it all. I've heard it a few
You
times.
probably, yeah, you wanna switch spots for just a minute? Okay, so you're Rochelle Manuel, and Miss Manuel, you were previously here and entered a plea of guilty to aggravated assault causing serious bodily injury. Have you been arrested for anything since that time? All right, then any reason not to go forward with sentencing?
No, Your Honor.
Mr. Parker, wait, you're not, I'm not done yet.
You that excited to go?
I still got to, I still got to say the words. All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. You understood the nature and the consequences of that plea. So I need this printed out and everything. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Yes, ma'am?
Question, would it be from the date of the incident or the date of the indictment?
It's, if you were in custody on this case, even before it was indicted, you'll get time for it. So if you were arrested and then you bonded out,
Now,
It occurred in the correctional facility, Your
she's,
Honor.
Yeah.
I think
yeah,
she's
yeah,
asking for time she won't get credit for.
oh, no, probably not.
So it happened in April, I should get credit from April to whatever.
It's gonna be when we had a hold on you or when the indictment was, whichever kind of came first. Okay?
It's fine.
So, you'll get credit for that. I am making an affirmative finding of a deadly weapon. Oh wait, or is there a deadly weapon or no?
No.
No, Your Honor, I don't believe it's alleged. No, it's not.
It's not, so I'm gonna retract that. All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker, right? Good. All right, good luck to you, ma'am. You can go back with the bailiff.
I only had one other case, Judge. and
Almeda
she-
Miles?
I don't think she's here. No. She is? Okay.
She had a warrant. Okay,
I haven't had a chance to talk to her at all.
I'll reset it, and now you know where she is. Good morning, sir. You are Daniel Jake Wise. And Mr. Wise, you're on probation for driving while intoxicated, third or more. And there was a motion to revoke filed. You were previously in court, entered pleas of true to counts 3, 4, and 5 in that motion. I have received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Are there any additions or corrections to the update?
Well, just some additions maybe, because when we left court, you ordered twice weekly UAs, and the reason was because he disputed the results of the drug patch. Now, since we left here, and probation's here, he's taken 2 UAs a week. He hasn't failed any of them.
Okay,
But what I don't know is if what the drug patch results were, because I don't believe probation gets them. But normally when the court gets them and they're a failure, they're sent to me. I haven't received any.
yeah, if we would have received a failure, that would have come through, I'm
And
sure.
we've got no notifications,
Yeah.
Judge.
Okay,
And I maybe can spare the court a little bit. Speaking with probation, speaking with Mr. Galmore, I don't feel that revocation is warranted. What I would be asking for, Judge, is maybe extension with JCDI.
he's, I saw that, he's on 5 years already for a state jail or a third?
It's a third, Your Honor. He's been extended, I think, once.
It's been extended one time,
year.
so we're at the end of 6
So
years.
we're at 6.
Right.
So we can
He's
do
really,
one
he's
more.
really at the finish line, Judge. There was a problem near the end, so.
Okay, thank you. Okay, and Mr. Patton, you're here, thank you, and you agree that the extension, what you put in your report with the JCDI would be appropriate?
Yes, Your Honor.
All right then, Mr.
Judge, may I?
Sure,
He wrote
Did
a
you want to
letter.
argue
I
against
did.
me leaving him on probation?
Well, not against leaving on probation. He did write a lengthy letter to the court.
He did, I've got it, I reviewed it.
Part of that, he explains his career path lately because of his hip replacement, going with that work for a long time. He is working at the shipyard now. He's got a job opportunity lined up, but he can't start it until he's off probation. So what he would like is to finish probation as quickly as possible, obviously. Because of his passing 2 drug tests per week, and that's really been his only issue for the entire 5 or 6 years of probation is those 2 tests from last year, or the turn of the year. Discussing with him, we were, at least our proposal would be to extend him for maybe 3 or 4 months and leave this twice-a-week drug testing on him and see if he can continue passing his drug test. If he does, then he could time out and expire and go get a better job.
Let me check, let me look through some things.
Per the administrative report, he's never had any problems on probation before.
So there was an administrative hearing. Looks like everything had to do with
This.
leading up to this. Is that correct, Mr. Patton?
We had 1 failed drug test in November, 1 failed alcohol test. There's a 3rd failed drug test that he disputes.
Right. Mr. Nichols?
It's hard for me to argue against that, Judge.
All right, so here's what I'm going to do, Mr. Wise. I'm going to find that you entered your pleas of true to counts 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I'm not going to do that today. I am going to extend your probation. What's the date? Let's see. May. So we just passed.
He's technically expired now, but for the
Look,
MPRP.
I'm doing math on my fingers up here. Okay. So if I extend it, does it extend from today or from the date? It would extend from the 13th of May.
That's correct, Your Honor.
So just from last month. All right, I'm going to extend it for 3 months. I am going to order the continuation of the drug test each week, how we've been doing it. Those go fine. Make sure everything else on probation's going fine, then you'll be off in a few months.
Continue the drug test also?
Yes. Yep, let's do everything just to make, and obviously if you're doing both and there's a discrepancy, then I'll have, 2 things to look at instead of just one. But if everything goes well between now and then, we shouldn't have any issues and you'll be off your probation in a few months. If not, any issues, we're right back in here, another motion to revoke, you're back in custody, and things probably won't go like this. You understand? All right, good luck to you, sir. Good morning, you're Joseph Gilbo. And Mr. Gilbo, you were previously in court and entered a plea of guilty to impersonating a public servant. I've received the pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections? Comments? Explanations?
Please? So obviously, we're talking about Mr. Gilbo's statement in the PSI, Judge. I spoke with him about.
Can I get everyone to please hold it down a little bit?
I spoke with him about this morning, and what he's telling me this morning is that the statement he made to the probation department is his version of events. I explained to him that based on it, my advice would be to, if the court will allow him to withdraw the plea and set it for trial. However, he wishes to proceed with the agreement and go be placed on probation.
Well, you can't say you didn't do it and get probation. It doesn't work like that. Because when you were here before, the clerk swore you in to tell the truth. And when you stood in front of me, I asked you a couple of very important questions. One was, were you pleading guilty freely and voluntary? And the second one was, are you pleading guilty because you actually did what they charged you with? And you answered yes to that. But if you didn't actually do what they charged you with, then you need to plead not guilty and let a jury decide. You can't say I didn't do it, but I don't want to go to trial. Does that make sense? Either you did it or you didn't do it.
Yes, ma'am. I did do it.
Okay.
The statement that they made was some of it wasn't true. But
Well, if some of it wasn't true, that's fine. But either you impersonated a public servant for some amount of time, ever so slight or whatever it was, either you did that or you didn't.
Yes, ma'am.
Did you do that?
I did.
Okay.
Yeah.
Any reason not to go forward then? All right then, anything else with regard to the pre-sentence report? Mr. Hoffpower, Mr. Rojas, anything else?
No, Your Honor.
All right, Mr. Gilbo, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 4 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And if you successfully complete the probation, at the end, the case is dismissed. You will never have the felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty of the offense and sentenced anywhere in the range of punishment, which is up to 10 years. Do you understand? All right, I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom and wait for probation. She's going to call you up when she's ready to go over your paperwork.
Yes, ma'am.
Good luck to you, sir.
Yes, ma'am. Thank you so much.
Jason Jones, sentencing, Mr. Rojas? Yeah, and I think... Oh, no, I'm holding it, but that's the one they're talking about.
Okay.
All right, sir, you Jason Jones, and in cause number 23, DCCR 0390, Mr. Jones, you were previously in court, entered a plea of guilty to unlawful possession of a firearm by a felon, and I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, Your Honor, we have.
And are there any additions or corrections?
Not from the defense.
No, Your Honor.
So, Mr. Jones, I've got some serious concerns with placing you on probation in this case because not only are you a convicted felon, it doesn't appear to me that you were just carrying a gun from one place to the other. You had two guns, chambered, 16 rounds in a magazine. You had extra rounds under your seat. You had a backpack with marijuana, another backpack, another suspected bag of marijuana in your cup holder. You had I just feel like there was more going on here. A scale. People don't carry around scales. People don't carry around that kind of marijuana. People don't carry around those kind of guns unless they're dealing drugs, period. And so the fact that you are already a convicted felon and out dealing drugs makes me wonder why we're giving you probation. Does that make sense? Are you working?
Well, I have an interview tomorrow. I had to reset it. I had to go in today to give them my ID and my social at Jefferson nursing home on Folsom.
Mm-hmm.
But I reset it for tomorrow.
If I test you this morning, you gonna have something in your system? Let's double check that. Have a seat in the jury box.
I think you've been on a drug patch.
Yes, I'm on the drug test, but
We're gonna double check. I just wanna be extra sure before I figure out what to do.
And Judge, I know those facts raise some questions. I was looking at his overall criminal history. The only felony he has is
I
the
know.
state jail for which he is found, which makes him felon possession.
I
So
think,
that's that was my thinking on it. I
I-
understand what the court's concern is, but that's
Yeah.
fine.
I think as long as we're okay this morning, I might just add a few little things, but I think we're good.
Okay,
Thank you.
Judge.
Mr. Cleese. Good morning, sir. Are you Jamal Joseph?
yes, ma'am.
And Mr. Joseph was previously in court, entered pleas of guilty to, in 2 cases, to burglary of a habitation, and those were both first-degree felony offenses. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor.
And so it says here the fine was to be determined. Is that was that left up to me?
Just left it to you, Judge, and I just wanted to let the court know, if you will recall, we did, obviously the criminal history is concerned. The factors underlying the burglary itself, the fact that he has full-time employment, the fact that the complainant is okay with probation, and the fact that he has pled to the higher first-degree charge, lending himself to that exposure if he's back for the reasons for that observation.
And it looks like, it wasn't necessarily on the front page, but it looks like there has been some requests for restitution in each of the cases.
Correct.
600 in 0493 and $160 in 0709. Is there any issue with me ordering that, Mr. Samuel?
No, Your Honor.
Okay, then at this time, Mr. Joseph, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 24, DCCR 0493, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 10 years. I'm going to order a $500 fine in that case and order that you pay restitution in that case in the amount of $600. You're also required to follow all of the rules and conditions of probation. And then in cause number 24, DCCR 0709, also find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow your agreement that you made and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine in that case also, and ordered to pay $150 in restitution in that case, and also follow all of the rules and conditions of probation. If you do all of this, then this is an excellent opportunity because you do not have these felony convictions on your record. And at the end of the probation period, the cases will be dismissed and you'll never have the felony convictions. The other side of that, however, is if you violate any condition of probation, you can be brought back into court. You could be found guilty in each of the cases, and the range of punishment that I could sentence you to in each of these cases is a minimum 5 years in prison up to 99 years or the rest of your life. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement in each case that I followed, so you've waived your right to appeal. And I do want to make sure, I want the restitution, at least half, to get paid, not wait till after the fines and all of that, okay? If you'll just, that's his. If you'll just have a seat here in the courtroom, probation will call you when she's ready to go over all your paperwork. All right, good luck to you, sir. Thank you, Mr. Samuel.
Excuse you.
Yes, sir. Have a good day. Good morning, you're Simone Dobbins. And Mr. Rojas, will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Dobbins, in cause number 24, DCCR 0504, you're charged with the state jail felony offense of driving while intoxicated with a child passenger under 15, and that's from December 9th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 4 years. You would be ordered to pay a $500 fine to follow all of the rules and conditions of probation, including having an auto ignition interlock device on any vehicle that you drive. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Dobbins is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay, see you back at sentencing. And then, Mr. Rojas, you have Joseph Gilbo sentencing. Good morning. Are you Isaiah Brown? And Mr. Brown, this is your initial appearance in cause number 25, DCCR 0356. You're charged with a 3rd-degree felony offense of abandoning.
Isaiah Brown.
Oh, I like that. Listen to this. What's happening?
Up here.
Wow. Okay, let's start over. Mr. Brown, in cause number 25 DCCR 0356, you're charged with the third-degree felony offense of abandoning or endangering a child with the intent to return from February 9th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I don't have the money for it.
Okay, you get a check from, you do? All right, so that means you qualify for a court-appointed lawyer. And so what I'm going to do is have you have a seat just for a minute, right over here in the courtroom. This